Good morning, sir. Hopefully you can see and hear us.
Yes, I can. Thank you.
Thank you. We'll be hearing from Mr. McCall this morning.
If you could stand, please. Bible in your right hand and repeat after me. I swear by Almighty God
I swear by Almighty God
that the evidence I shall give
that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you.
Thank you.
Please could you state your full name?
Kenneth McCall.
Mr. McCall, in front of you there should be a witness statement. Do you have that?
I do, thank you.
Firstly, can I thank you for providing that written statement and for attending the inquiry today to answer questions about it. Before I ask you to turn to your signature, I understand there's one small correction to be made. Please could we have on the screen page 30, paragraph 65 of the statement. In that paragraph, you say at the start that you received Mr. Cooper's call at around 8 o'clock, and we'll come to this section in the course of your questions. Just for the purpose of the correction, midway down the paragraph, it says, shortly after the call with Mr. Parker, I rang Ms. Stent, and I understand that you wish to change that to shortly after the call with Mr. Cooper. Is that correct?
Yes.
Thank you. That can come down from the screen. Thank you. Mr. McCall, can I ask you, please, to turn to page 35 of your statement? Do you see a signature?
I do.
Is that your signature?
It is.
And subject to the one correction we've just made, are the contents of that statement true to the best of your knowledge and belief?
They are.
Thank you. That stands as your evidence in the inquiry. It will be published on the website shortly. And for the purpose of the record, the unique reference number is WITN 100200100. I'm going to ask you some questions about it, but not all aspects of it. I'll start with your background, well, actually your role at Post Office Limited. You were the Senior Independent Director of Post Office Limited from January 2016 to January 2022. Is that right?
That's correct.
Then looking at your background, you spent the first part of your career at TNT. Is that right?
That's correct.
And you became the CEO for Asia and then CEO for China at TNT.
I did.
You joined DHL in 2007.
Correct.
And you then joined the Eurocar Group, becoming Deputy Group CEO in 2016.
That's correct.
So was that an executive position at Eurocar?
Europcar was an executive position.
And what was the time commitment for that role?
I was a full-time executive at Europcar on a normal basis, 5 days a week, or as required.
And in practice, was it a 5-day-a-week job, or did it involve weekend work as well?
It involved weekend work as well.
You have been you had been a non-executive director of Superdry, is that right?
That's correct.
When did you begin that role?
From my witness statement, it would be 6 years prior to then, I recall. So I served 2 terms at Superdry, enjoying the post office in 2016, so it would be 2010.
And was there any overlap between your Superdry appointment and your appointment as senior independent director at Post Office?
No, I don't recall there being so.
Did you have any other non-executive roles whilst you were at the Post Office?
I did not.
I understand that your contractual time commitment as senior independent director was 2 days per month whilst at Post Office.
That's correct.
Did you have sufficient time to meet your commitment to the Post Office, given your executive commitments to Europcar?
Yes, I did.
You say in your statement at paragraph 9, we don't need to bring it up on the screen, that Tim Parker thought you would be a good fit at Post Office, and you refer to your experience in parcels and mails. Yes?
Yes.
At that point, later in your statement, you also refer to having some experience of dealing with IT issues at an executive level. Is that right?
Yes.
Could you briefly just summarise what that IT experience was?
My IT experience, I was responsible at Europcar Group for the business priorities of the IT function, which was headquartered in Paris. So I would decide exactly what the business required of the IT department and liaise with them.
Did you find that experience assisted you in your roles as Senior Independent Director at the Post Office?
From a business perspective, yes. From a technical perspective, not necessarily.
And why not from a technical perspective?
I'm sorry, a big one?
Why not from a technical perspective?
Because my role at Europcar wasn't a technical role. It wasn't deciding systems or otherwise. It was purely, what does the business require? What do our customers want?
When you were a Senior Independent Director at Post Office, do you think its board had sufficient technical IT experience to handle the issues before it?
Yes, I do. We had an excellent CIO, Mr. Houghton. I had two fellow non-executive board colleagues who came from the IT and technology sectors, and therefore at least two of the board, to my knowledge, were very IT savvy and knowledgeable.
You say in your statement that to the best of your knowledge, the companies you had worked for prior to the Post Office did not pursue private prosecutions.
That's correct.
Was there anyone on the board with legal experience or qualifications?
Latterly, I believe, if I recall correctly, a year before the end of my second term, we had a non-executive director join, who's still there, I believe, at the present time, who is from the legal profession.
Can you name that person, if you can remember the name?
I don't immediately recall. Yes, I do now. Mr. Tidswell.
Do you think the Post Office board would have been assisted by having a member of the board who had legal experience or qualifications, considering the matters you were dealing with during your time there?
I believe that latterly the assistance of Mr. Tidswell was extremely helpful in guiding the board through some of the processes. So, yes,
I pause you there. When you say some of the processes, what processes are you
I think
referring?
Understanding what decisions we require to make and why, and how to maybe understand a bit better the details.
The details of what?
The details of the options that we had.
I'll ask it another way. Are you referring to legal issues to which this inquiry relates, such as compensation and criminal appeals?
Yes.
Do you think it would have assisted the Post Office board then to have experience such as that on the board when you were dealing with the group litigation?
At the time when I joined the Post Office board, I did not know anything about the group litigation, so therefore in joining I wouldn't have had an opinion that said we would benefit from having legal expertise. Having then gone through the group litigation, I would say yes, it would have benefited the board.
I want to look at your role as the Senior Non-Executive Director. So the inquiry has heard evidence that, and is well aware that both the shareholder executive and then UKGI appointed a shareholder non-executive director to represent its shareholding interest at the board, correct?
Yes.
As a non-executive director, in whose interest did you act?
In the interest of the shareholder.
And in order to act, how did you determine what those interests were?
In a company that's either a listed company or certainly multi-shareholding, you're acting on behalf of that as a shareholder. In this case, in the government company, I was acting on behalf of the government shareholder to bring my expertise and experience to bear on a post office board.
The government shareholding interest in Post Office Limited wasn't simply to see Post Office making a profit. Would you agree with that?
That statement was never something that was in my terms of reference, or it was never made to me specifically. My view was that my role was to try and ensure a sustainable business model for Post Office looking forward.
Can you summarise, in your view, what distinguished your role as Senior Independent Director from that of the other non-executive directors?
I was responsible for reviewing the performance of the chairman. I was the conduit for the other non-executive directors if they needed any help or advice. In some ways, I was the go-between also to the chairman, where I would advise the chairman if there were any concerns of the non-executive directors. So, in simple terms, I would say at a high level, I was eyes and ears.
The responsibility you referred to of evaluating the chair's performance, in one way that was carried out through yearly evaluations, is that right?
That's correct.
Would you see your responsibility for evaluating the chair's performance as an ongoing matter, though? You had to keep on top of the chair's conduct and effectiveness?
Yes, in principle. I think through the COVID period where we were meeting remotely, I don't recall exactly the process we went through, but through the COVID period it was extremely difficult. It was about survival and it was about trying to keep a business together. So I don't recall specifically the chairman's performance review. When it was done face-to-face, I recall it quite specifically.
In your role as non-executive director and protecting or acting in the interests of the shareholder, to what extent did you have meetings with the minister with responsibility for Post Office in your role as Senior Independent Director?
I don't recall how many meetings I had with the Postal Minister. Possibly one or two, nothing more. And again, please bear in mind that through the period we had 3 years of COVID as a part of that exercise, so therefore no one was meeting anyone face-to-face. I met the chairman of BAYS, at that time, I believe now BIS, and I met possibly one other minister as a part of that exercise. So I didn't regularly meet a postal minister.
Before the hand-down of the Common Issues judgment in March 2019, had you had any conversation with the Postal Minister or indeed the Secretary of State about the allegations concerning the robustness of the Horizon IT system or the group litigation?
No, I don't recall I did.
To what extent would you meet representatives of the shareholder UKGI, outside of meeting Tom Cooper in board meetings?
I would meet possibly Richard Callard, who first was the prior to Tom Cooper. Tom Cooper afterwards, either for a coffee beforehand or after a board meeting. I don't recall any formal meetings at their offices as a part of that. I had a conference call once with the permanent secretary, but other than those, I don't recall any.
The conference call with the permanent secretary, do you recall when that was?
I don't recall the specific date.
Did you discuss issues relating to the allegations of a lack of robustness in Horizon or the group litigation?
No, I did not.
Do you recall what you discussed?
Frankly, I can't remember the date. I can't recall the date, so I think I would just be hypothesizing. So, no, I don't remember.
Please can we bring up your statement at page 5, paragraph 14. You're referring to your role and responsibilities as a non-executive director, and at the end of paragraph 14 you say, at a high level, my role as a non-executive director was to be part of a board developing Post Office's strategy to achieve financial self-sustainability and to work with the management team to deliver that. And then over the page at paragraph 16, go down, please. Towards the bottom half of that paragraph, you say, our role as non-executives on the board is to help determine the company's future direction and strategy. In other words, we are focused on what the company might look like in several years' time and how we can create a sustainable and future-proof business. So strategy is forward-looking. Would you accept that to be able to advise on strategy, a non-executive has to consider risk to the business arising from past liabilities or current operations?
From a strategic point of view, the focus of a non-exec will be looking at the marketplace that the business operates in, the business model that it's using in that marketplace, and how we might improve that business model to ensure that, in this case, the Post Office remained a leading player in the mails, parcels and logistics market. And that was the focus of sustainability as a business.
Do you think that following the hand down of common issues, the Post Office's future strategy and its sustainability changed as a result of that judgment?
After the common issues judgment, there was, I believe, about 8 or 9 work streams that were started as a result of the common issues judgment, looking at the remarks and comments made by Justice Fraser and the requirement for the Post Office to substantially change its way of operating and its relationship with the sub-postmasters.
So I think you're agreeing with me that things changed significantly following the common issues.
There had to be significant change.
The common issues judgment considered and made findings on matters that happened in the past. Would you agree?
Predominantly, yes.
So was it not the role of the board, including the non-executives, to look at the past as well, to determine what risks in future, or assess what risk in future may be on the horizon?
As a non-executive, I'm always looking at forward, not looking back, and looking at our business model. And in this case, after the Common Issues judgment, we're looking at what changes required to be made that was the result of the judgment. And so that was really the focus, as opposed to looking historically.
Do you think the executive team had a role in identifying, analysing and mitigating risks for things that happened in the past?
The executive team, from the outcome of the Common Issues judgment...
Stop you there, sorry. I'm not talking out from the Common Issues judgment here. As a matter of generality, when you joined the Post Office in 2016, did the executive team have a responsibility to identify, analyse and mitigate risks that the Post Office Limited faced?
Yes, as a general principle, yes.
Did the non-executive directors have a role in overseeing that aspect of risk management?
Yes, mainly through the Audit and Risk Committee.
And what did you see as the non-executive director's role in challenging the executive team's delivery of its operations?
The robustness of the strategy, the business operating model, the product evaluation, the customer service requirements, the detailed operating requirements of running a business, and what we had to change and what the executive team were focused on day to day.
So did the non-executive directors, including yourself, from 2016 onwards, have a role in overseeing the executive team's analysis of the risk posed by the Horizon allegations?
When I joined the board in January 2016, I was completely unaware of the Horizon issues, bugs, and historical problems. And therefore, in my mind, when I joined in 2016, my focus was on building a sustainable business model and future. It wasn't focused on looking back. I was completely unawares of the history and what had recently happened. I then became aware in April 16.
Okay. Well, I'm going to cover that shortly, so we'll come back to that topic. But before I do, I want to ask you a couple of questions on materiality, which appears in your statement at a few places. Please, could we have up page 6, paragraph 17 of the statement? Thank you. You say at the bottom there that the board will not consider the specifics of individual bugs or defects, which is generally the responsibility of the specialist in the IT team, save to the extent that those bugs or defects have a material impact on the day-to-day running of the company. And then at paragraph 18, you say typically a non-executive board would have high-level oversight of the conduct of any civil litigation brought by or against the company, but only if and when it became material. Each company will have its own materiality threshold, and unless a civil claim met that threshold, I would not necessarily expect the board to be made aware of it or updated on its progress. How was the threshold of materiality determined at the Post Office Board in 2016 to 2019?
In my witness statement comments, I refer to materiality as if it would be determined by the auditors. So the statement would be based on, normally, if I recall correctly, a percentage of turnover. So in this case, my use of the term materiality would be a percentage of turnover of the post office, and that's the reference that I make by materiality. So in the case, if I recall correctly, then it would be many millions, but that's the use of the word materiality.
We've heard this before in the inquiry of exactly the definition you describe, and would you accept that the materiality from the perspective of the Post Office Limited Board would be different from materiality to an individual sub-postmaster?
Yes, I would.
In terms of the allegations that, sorry, before I ask that question, did the board, when you were there, ever consider the post office, sub-postmaster's perspective of materiality?
The comment on materiality was driven by the auditor definition, or from an annual accounts perspective. We didn't look at it, as I recall, from a sub-postmaster perspective.
In terms of the allegations that were made that Post Office had secured convictions using unsafe convictions using data generated by the Horizon IT system, so the allegation of an unsafe conviction, is that a matter that should be considered at board level, or is there a test of materiality for unsafe convictions?
When I joined the board in January 2016, to the best of my knowledge, there was no convictions, and none of the existing board members at that time had sat on the board previously, and so therefore I find it hard to comment on your question.
Can I just clarify with you what you mean by no convictions there? Do you mean when you were senior independent director, Post Office didn't secure, you believe Post Office didn't pursue prosecutions that led to convictions in that time?
That is my understanding.
Let's look at your appointment letter, please. It's Poll 203629996. So we see it's dated the 2nd of December 2015. And if we could turn to page 8, please. It refers to an induction saying, after the commencement of your appointment, the company will provide a comprehensive, formal and tailored induction. We will arrange for site visits and meetings with senior and middle management. What induction did you actually receive by Post Office?
I met most of the senior executive team face-to-face at Post Office offices.
Can we just so we can be clear, when you say the senior executive team, most of, who are you referring to?
I'm referring to the person that was in charge of the banking business, or the person that was in charge of the mails business, so the people that were leading the various business units of Post Office. I met the Chief Financial Officer. In addition to that, I met the Chief Executive. So I mean the sort of top line executive team. I don't recall how many of the people I met but I met a number of the top-line team. After that, I then did some external site visits, and I visited some sub-post offices in the network. If I recall correctly, probably 4 or 5 sub-postmaster network offices.
Did you meet anyone from the legal department as part of your induction?
No, I did not.
So, for example, Jane McLeod, you didn't meet her as part of your induction?
No.
Please, can we bring up your statement, page 33, paragraph 73? You're giving your reflections here, and you say, when I joined Post Office, the board was still relatively new, and to my knowledge, none of the non-executive directors had been in post at the time when the legacy Horizon system was in operation and the private criminal prosecutions were still ongoing. I can recall feeling as though we had been left holding the baby, and we had to decide what to do with it based on our limited background knowledge. What in particular left you feel as if you were holding the baby?
Not having a non-executive on the board who understand what had happened for the previous 1, 2, 3, 4 years, and not having that knowledge.
And when did you get this feeling?
My comments were quite general when I started to find out about the Horizon issues, which was between April and September of 2016, that there was no one when I looked at my colleagues who was in position prior to that.
So reading this, you say the first sentence, when I joined Post Office Limited. The second statement, I say a sentence, sorry, I can recall feeling as though being left holding the baby. Your evidence is that that happened later in April 2016 onwards, rather than when you joined Post Office Limited.
That's correct.
That document can come down, thank you. You refer, we don't need to turn it up, but in your witness statement, you refer to having an interview with Baroness Neville Rolfe prior to your appointment as Senior Independent Director.
Yes, that's correct.
And your evidence is that she didn't discuss with you matters such as the allegations regarding Horizon or Tim Parker's review.
That's correct.
How confident are you, now looking back, that she made no reference to the Parker review in that interview?
Very confident.
Why?
Because I would have remembered something as significant if there was a major issue that had been identified to me at the time before I was likely to join a new board. So I'm as confident as I can be. Bear in mind, I'm talking 8 years ago, that I recall that nothing was mentioned about the historical issues.
Do you remember what briefing material, written material, was provided to you as part of your induction?
No, I don't.
As part of your Rule 9 request, the inquiry sent you a number of documents and asked you when you first had knowledge of them. Can we turn, please, to page 18 of your statement, paragraph 41? You say towards the bottom of that paragraph, oh sorry, I'll wait for you to get on screen. You say towards the bottom of that paragraph, I now realise that by this time, and you're referring to the 30th of October 2018, we see at the top, I now realise by this time several reports have been commissioned by Post Office into possible issues with Horizon, and I have been provided with copies of certain reports dating back to 2013. Except as set out in this statement, I had no knowledge of any report of those reports until they were provided by the inquiry. In that sentence, are you referring to documents such as the second site interim report in 2013, which commented on the it commented on the Horizon system itself?
Yes. The first that I've seen of any reports on the Horizon system were in documentation provided by the inquiry.
Please can we turn to POL 406357. It's a document very well known to the inquiry. It's Simon Clark's advice of the 15th of July 2013. It was sent with the Rule 9 request to you and was one of the documents that the inquiry asked you about. Did you read it when preparing for this statement?
No, I did not, because I wasn't in position in 2013.
So, are you aware of what this document says?
No, I'm not.
If we, firstly, before I ask what it says, when did you first see this document?
Only when it was presented to me as part of the papers from the inquiry.
Why did you not refer to it in your witness statement?
I didn't believe that it was relevant to me on the basis that I wasn't in position and didn't know anything about it. And so therefore I'd struggle to comment on it.
If we turn, please, to page 13. We see under conclusions, it says, what does this all mean? In short, it means that, and it says Dr. Jennings, which refers to Gareth Jenkins. Presumably now you know who Gareth Jenkins is.
Yes, I do.
Gareth Jenkins has not complied with his duties to the court, the prosecution or the defence. And if we go down at 38, we don't need to go through it all, but it says Dr. Jenkins failed to disclose material known to him, but which undermines his expert opinion. This failure is in plain breach of his duty as an expert witness, and continues. Were you provided any information regarding Gareth Jenkins when you joined the Post Office?
I was not.
When was the first time you heard of Gareth Jenkins?
The first time I'd heard about Horizon issues was between April and September 2016, after I joined in the January 2016. I don't recall exactly when I found out about Gareth Jenkins. I don't have a date of recollection in my mind.
Do you recall when you found out about the allegation that Mr. Jenkins had failed to comply with his duties as an expert?
I don't know about duties as an expert, but in terms of ability to access the system, I believe that was in November, December 2019.
When you say ability to access the system, do you mean remote what we now refer to as remote
Yes,
access?
I believe so, yes.
I mean, can you assist us with whether you were aware of concerns about Mr. Jenkins before the common issues judgment?
No, I was absolutely not.
Again, I'll phrase it slightly wider. Do you recall when the first time you became aware of concerns with Mr. Jenkins within Post Office?
I don't recall an exact date.
Can you give us a time period?
Only when I go back to my November, December 2019, when I heard the system could be remotely accessed. That's probably the first time. I don't remember anything prior to that.
Did you discuss concerns about Mr. Jenkins with anyone else on the board?
No, I did not.
Could we look at the monitoring, please, of the group litigation? We don't need to... Actually, no, let's bring it up, please. Your statement, page 16, paragraph 37. You say, initially Ms McLeod delivered updates to the full board on the status of the GLO proceedings, which soon became a standing agenda item. These updates were necessarily limited to high-level news and headlines, how many claimants had joined the claim, whether there was going to be a class action, and similar key issues and milestones. From a very early stage, there was a huge amount of detail in the GLO proceedings that the board would not have had time to review, and it was not the board's role to do so. Looking at the board minutes I've been provided with by the inquiry, the notes of Ms McLeod's updates appear quite light. It's not clear to me now why the chairman did not request more detail in the minutes. And you refer to Ms McLeod's preoccupation with preserving privilege. So just clarifying this, is your evidence that actually, as a matter of fact, Ms McLeod provided more substantial briefings to the board orally than is reflected in the minutes?
Mrs McLeod provided updates to the board that were almost verbal, that I recall.
Yes, and when she provided those verbal updates, is your evidence that what she actually said to you when you were in the boardroom was more substantive or provided more information than is reflected in the board minutes?
No, I don't recall specifically because everything was verbal. I find it hard to recall whether it was more detailed or less detailed. I just recall it was a verbal update, and the minutes reflected that update being quite light. I don't know why, but Mrs McLeod wouldn't present for 1 hour or otherwise. It was a short session that I recall, verbally updated on the high-level points of the litigation.
Well, what do you mean by it is not clear to me now why the chairman did not request more detail in the minutes? Are you saying that the chairman should have requested there to be more detail written down as to what Ms McLeod actually said, or that the chairman should have requested that Ms McLeod provide more detail to the board?
I'm saying that the chairman should have requested more detail in the minutes.
And so, from your recollection there, in saying that, what do you think is missing? What sort of information is missing from the minutes that has led you to make that statement?
The basis of my comments relate to receiving information from the inquiry. If I was able to read it now, it would give me a better understanding of what was said and what happened during those meetings, if the minutes were more detailed. So my comments are really driven by recollection of memory as opposed to anything else.
Why didn't you raise any concerns about the minutes at the time?
In hindsight, I should have done.
Please, can we bring up poll 2424270? So we know and have heard evidence that there was initially a steering group for the GLO, and then the board created a subcommittee in early 2018. In fact, we see it paragraph 2.1. It says it's following the meeting of the 29th of January 2018. In your witness statement, you refer to one of the purposes of the committee to be to receive legal advice. Was it also to provide oversight for how the litigation was being conducted?
If I recall correctly, there is terms of reference. There were a terms of reference of the subcommittee in documents. I haven't seen it as part of my papers, but if I recall, there was terms of reference, and the day-to-day management of the subcommittee and working with the legal officers representing Post Office was the duty of the company secretary or legal team, Jane McLeod, and the executive. Then, after that, if there was anything required to be escalated, then that would be escalated to the subcommittee.
So that can come down for the time being, thank you. What did you see, leaving aside what the formal terms of reference said, as a matter of practice, what did you see your role to be on the subcommittee?
The group litigation, as I first found out about in between April and September 16, started to snowball very quickly. There was approximately 90 claimants, and that snowballed very quickly into 550 or 560 claimants. And so things were moving very fast. And the role of the subcommittee was to be able to try and quickly react if there was any decisions or any advice that was required, because it was happening so fast. Decisions had to be made, and so therefore the purpose, as much as anything, of the subcommittee was to try and assist the board in understanding what was happening and to be available if the executive or Mrs. McLeod had to escalate anything that required further discussion.
And can you give us a summary of what types of things were escalated to the subcommittee?
I don't recall specific documents or items at the moment, and in my papers provided by the inquiry, there wasn't any documents that I can give as an example, but it was more about the frequency and the feed of information that was coming very quickly.
I want to look at a different topic, please, and that's what we now call the Swift Review, or Tim Parker's review. When did you first become aware of Tim Parker's review as commissioned by Baroness Neville Rolfe?
I never was aware of the Swift Review until the papers and I saw the documents provided by the inquiry.
So I want to try to delineate two things here. Firstly, when were you aware that Tim Parker was carrying out a review at the request of Baroness Neville Rolfe?
I wasn't aware at all, and I was never informed of that at all.
And the second question I was going to ask is, when did you become involved with, when did you become aware of Sir Jonathan Swift's involvement? And your evidence is, and you didn't see the report, the advice, until it was sent to you by the inquiry.
That's correct.
Apologies if I've misheard you, but just so I can be clear, that's when you saw the advice produced by Sir Jonathan Swift. When did you become aware of his actual involvement?
His being, can you just clarify?
So I'm very sorry, yes. Sir Jonathan Swift's involvement.
The name Swift I was not aware of. It's not a name that I was aware of. I believe when I looked through the papers provided by the inquiry, there's a comment from Tom Cooper which says, I attach, and I don't believe he names anything, but he attaches a document. I don't recall ever receiving that or seeing that document, but I've read the papers provided by the inquiry, but to the best of my recollection, it doesn't mention a name, and I don't remember seeing it. So physically seeing what was the Swift report and the letter to Baroness Neville Rolfe, I didn't see it until it was provided by the inquiry.
I want to bring up, please, Jay McLeod's witness statement. It's WITN 100101000. This is a witness statement provided to the inquiry by Jay McLeod, dated the 30th of April 2024, which has been read into the record. Can we please turn to page 101? And if we could go down, please. No, sorry, it should be starting at page 100, paragraph 184. So we see at the top there, referring to at 183, Sir Jonathan Swift providing a draft version of his findings to Mr. Parker. At 184, Jay McLeod says that I have not been provided with the minutes of any board meetings or group executive meetings in which the chairman's review or the findings from it were discussed. Although it is clear that the board were aware that it had been commissioned, as the CEO informed the board at its meeting on 22nd of September 2015, pausing there, that's before you joined the post office, that the minister had asked the chairman for his independent review of Sparrow. It then goes on, if you see further down, it says, it refers to Mr. Parker's comments in open source material. He says, my recollection is different to Mr. Parker's, although I agree that I discussed privilege and confidentiality with him when I met him. My recollection is that the senior independent director, Mr. McCall, asked a question at a board meeting as to whether the board would be briefed on the findings of the chairman's review, although I do not now recall the exact timing, but it was after the further work recommended by the chairman's review had commenced. Pausing there, do you recall asking such a question as indicated by Mrs. McLeod here?
No, I don't.
So, in your evidence, where we saw you refer to feeling being left holding the baby, you weren't referring to learning of the chairman's review?
I have not seen that document, nor have I questioned it, nor have I said I have a totally different recollection. Otherwise, I would have not have made the comments in my witness statement.
I'm just going to continue with what she says, in fairness to you, so it's put to you. I believe that as a result of that question, so this is Jay McLeod speaking, I provided an oral briefing to the board, although I do not recall if this was at the same meeting or subsequently, as to the scope and findings of the chairman's review, as well as a summary of the further work being undertaken following the chairman's review. Again, I'll put it to you. Do you disagree then with Ms McLeod's recollection?
I have absolutely an alternative view on that. I have never, and I stress again, I have never seen that report, nor do I recall in any way that I made those statements or that word.
And finally, she says, although I have not seen the documents which indicate that the full report was circulated to the board, my recollection is that I advised the board that the full report was available on request. Do you agree with that?
No, I do not.
That can come down, thank you. Could we please bring up poll 30024913? It's a letter from Tim Parker to Baroness Neville Rolfe regarding his review, dated the 4th of March 2016. I think you've already referred to it, but for clarity I will ask, did you see this at the time?
No, I did not.
When was the first time you became aware of this letter?
In the papers provided to me by the inquiry.
Could we turn please to page 2? And if we go down to the criminal prosecution section, we don't need to read it all. It sets out some information on the review and the criminal prosecution's element of it. And one, it says, well, above one, it says, as a result of the review, I have decided to take the following steps. It says, I will take advice from specialist criminal counsel as to whether the decision to charge theft and false accounting could undermine the safety of any conviction for false accounting if A, the conviction was on the basis of a guilty plea following which and or in return for which the theft charge was dropped, and B, there had not been a sufficient evidential basis to bring the theft charge. Were you aware of that work described there having been commissioned?
No, I was not.
Do you think you should have been made aware of that?
My first board meeting was in February 16, and I noticed from seeing the letter again, it's March. But yes, naturally, in the course of events, I believe I should have been aware of it, but I was not aware of the letter at all.
If we turn the page, please, page 3. There's information on Horizon, and it refers to, firstly, various bugs, errors and defects. We don't need to go to that. It's the second 2 paragraphs I want to refer to. Nevertheless, the report suggested that consideration should be given to whether it would be possible, by analysis of the transaction logs of sub-postmasters who made complaints, to determine more comprehensively whether or not the matters complained of by each sub-postmaster could show the existence of some other generic bug within the system. Work is now underway to assess if such testing is possible, and if so, to scope the work that would need to be done. And then it goes on to say, further work is also underway to address suggestions that branch accounts might have been remotely altered without complainant's knowledge. Were you aware of one or either of those recommendations or work being carried out further to them?
No, I was not.
That can come down, thank you. Can we bring up UKGI 30122703? It's an email from Tom Cooper on the 16th of September 2020. We see in the distribution list and the CC list there are various senior figures at UKGI and then what was Bayes, the Permanent Secretary included. He says, ahead of our call this afternoon, this is just to update you that Ken McCall, the Senior Independent Director, has confirmed that, having spoken to other members of the board as he deemed appropriate, he does not think it appropriate to take action in relation to Tim Parker's decision-making around the QC's review in 2015, referring to the Swift review, of Post Office's handling of the Horizon complaints. His rationale is the same as reported previously. Ken believes Tim made a significant error of judgment in accepting legal advice at the QC's report and, as a consequence of the follow-up work, should not be shared with the board. Does that fairly summarise any work you carried out following your discovery of the Chairman's review?
The Chairman's review, and you're talking the Chairman's, just for clarity, you're talking the Chairman's review of performance.
Well, I'm saying once you were asked to conduct a... Well, no, let's pause here. This says that he does not think it appropriate to take any action in relation to Tim Parker's decision-making around the QC's review in 2015 of Post Office Limited's handling of the Horizon complaints. And then it goes on to say that you believed that he made a significant error of judgment in accepting legal advice that the QC's report, namely Jonathan Swift's report, and as a consequence, the follow-up work should not be shared with the board. Will this suggest that by September 2020 you were aware of the Swift review?
No, because by name, I wasn't aware what anything was called. Just for clarity, I don't recall the term Swift, and I don't see it in this document, and I've not seen it in anything that's been provided to me that would indicate, better than my recollection, that I have seen, and this refers to the Swift report. So my understanding is that the chairman conducted a review. I did not know what it was called or what it was, and it wasn't shared with the board. But the name of Swift was not known to me.
Were you aware that he had instructed a barrister to assist with the review?
No, I was not.
So is your evidence that Tom Cooper here, when saying Ken believes Tim made a significant error of judgment in accepting legal advice that the QC's report and, as a consequence, the follow-up work should not be shared with the board, your evidence is that's inaccurate?
My evidence is that if there was something as serious as that having taken place, then I believe the chairman should have shared it with the board.
That's a separate question. I'm asking, on this email from Tom Cooper, the suggestion is that you had evaluated Mr. Parker's performance and determined he'd made a significant error of judgment in failing to share legal advice that in the form of what's described as the QC's report, and failing to share that with the board. Is that wrong?
My conversation with Tom Cooper, to the best of my recollection, there wasn't a reference in our conversation to QC. So therefore, I just recall Tom saying, Tim Parker has carried out a review. It's not been shared by the board. I don't recall there being a name given to that document or QC's document. And the email here is much more direct than the conversation that we had. So my conversation with Tom Cooper was, apparently there's been a document that Tim has commissioned and it's not been shared by the board. It was his general as a recollection as that I have. So here it's very specific. It says in this email, which obviously I'm not a party to and didn't see, then you know, it's a much more strongly worded than the phone conversation with Tom Cooper with me was.
Did you say to Tom Cooper that you thought, on the information you had, that Tim Parker had made a significant error of judgment?
If there's a major report that the chairman should have shared with the board, then that's why I would refer to it as a significant error of judgment.
So in saying you would have referred to it as a significant error of judgment, you said if there was a major report. What were you told for you to believe there was a major report that he'd failed to share with the board?
Verbally from Tom Cooper.
And what did he say specifically about that report?
I mean, we're talking 4 years ago or thereabouts. I don't specifically recall the exact conversation, but the chairman had commissioned a report and it's not been shared with the board. That is the essence of the conversation. There was no reference to SWIFT, there was no reference to QC, and so I don't understand how Tom knows those factors or QC's report. I certainly didn't know those factors.
Have I got this right, Mr. McCall, that you accept that there was a conversation with Mr. Cooper either shortly before or on the date of this email? In that conversation, he told you that Mr. Parker had received a report which had not been shared with the board. You were told enough to consider that that was a significant error of judgment on the part of Mr. Parker, but given his overall record, you did not think that any action should be taken against him in respect of that error of judgment. You, however, dispute the fact that you were aware either of the name SWIFT or that the report was carried out by a barrister. Now, is that a fair summary of what you've been debating with Mr. Stevens?
Yes, sir. That's correct, sir.
Fine. Thank you.
Please can we bring up UKGI 3012155. I think this is a document you were referring to earlier. We see, it says from Tom Cooper at the top. 2 includes Tim Parker, and you're there as well, Ken McCall. Subject Chairman's Review Report. Attachment QC Post Office Review, 7th Feb 2016. And then also the letter to Baroness Neville Rolfe, dated 4th March 2016. As promised yesterday, please find attached a copy of the QC's report prepared for Tim in 2016. The recommendations are at the back. I also attaching a copy of Tim's letter to the Minister. Do you accept you did receive the SWIFT review?
No, I do not. I accept I saw in the documents provided to me that this is exactly what it says, but I have no recollection of actually having seen that report.
Is it not the case that you, on the 30th of July 2020, received the SWIFT review, and then later, in the email we just went to, gave Tom Cooper your views on it, namely, having read the report, you thought that it should have been disclosed to the board?
I don't believe so. To the best of my recollection, I believe I would remember or have remembered if I saw a document such as this.
So that's probably a good time to take our break, and I wonder if we could come back at 25 past.
Yes, that's fine, Mr. Stevens. I was just checking the time. Yeah.
Thank you, sir. Can you still see and hear us?
Yes, thank you.
Please could we bring up poll 204104-107. So we see this is an email from you to Veronica Branton and others on the board on the 22nd of April 2020. We'll come to it in a moment. You say, I would appreciate seeing a redraft of the minutes to include the points raised by Tom. And that's an email from Tom Cooper, to which we'll turn in a moment. Before we do, he says, I must say at this stage, I do not feel comfortable that the minutes truly reflect the complete unawareness of the board to the existence of a Deloitte report, whom it was commissioned by, and the contents therein, and that the minutes reflect the complete shock at finding out that Fujitsu had remote access. Now, pausing there, the inquiry has sent you two sets of, well, several reports from Deloitte, but in two sets broadly. One, Project Zebra from 2014, and one, Project Bramble from 2016 onwards. When you say the existence of a Deloitte report, to what are you referring?
I wasn't aware, if I recall correctly, that there was more than one, so I don't have a name or a badge that I can give to that report. I didn't know that there was multiple Deloitte reports. Only in the papers that were sent to me by the inquiry was I aware that there was multiple Deloitte documents.
So is your evidence you were, at this point, you were aware of no Deloitte reports regarding remote access?
That's correct.
And when you say things like complete shock and complete unawareness, do we take from that that you think the Deloitte report should have been before the board?
That was my perception, that someone had commissioned a report and the board hasn't seen it.
So did you think it was an important report?
That was my perception at the time, that there was a report and that the board should have seen it. And so my words used then are complete unawareness by the board. And I believe myself and my fellow colleagues on the board, specifically I refer to the non-executives, would have felt the same way.
So if you'd known earlier that there was a report by Deloitte that dealt with remote access, would you have wanted to know more about it?
Yes, I would.
Could we go, before we move on to look at that in more detail, I want to look at Tom Cooper's email, which you referred to there. So as I say, you say, I would appreciate seeing a redraft of the minutes to include the points raised by Tom. If you could go to the bottom of the page. See, that is the email from Tom Cooper. You are sent it, we can see on the right side. And then if we go to see the meeting, it says, Veronica, I've got a few points on the minutes from the last meeting. Something at paragraph 7 about the Deloitte report. He says, I'd like to clarify that the who knew about question should apply to the various pieces of work commissioned. And you see the third one is following the Jonathan Swift QC report. So you were aware that it was Jonathan Swift QC who prepared a report by at least the 22nd of April 2020. Would you accept that?
I accept it when I see it here in email, but day to day, I don't have any recollection of that specific email, and I don't have a recollection of the name, but there is an email here which I read the title and I see it and I accept, but it's not something that had any retention for.
Looking back now then, would you accept that firstly you knew Jonathan Swift had commissioned a report, it was later sent to you, and you told Tom Cooper that Tim Parker should have disclosed it to the board?
I see the paper trail in the email trail. I have no recollection of receiving the Jonathan Swift report. I have none at all.
So are there two options really? One is your recollection's inaccurate and you did receive it and read it, or secondly, an obviously important report that you were sent, you didn't open.
The former, in that I have no recollection of receiving the Swift report.
Actually, the former thing I said is that your recollection is incorrect.
Yes.
Are you accepting your recollection is incorrect?
When I see the paper trail, you would have to say, yes, that's potentially the case.
That document can come down, please. Could we please look at your statement, page 29, paragraph 63. You say at some point during the board's review of CCRC cases, I received a telephone call from Mr. Cooper regarding a Deloitte report that Mr. Parker appeared to have commissioned but had not shared with the board. You go on in that paragraph to say you believe now that he was referring to Project Bramble, which, as I said earlier, was the post-2016 work. If we can turn the page, please, to paragraph 66. You say, during the CCRC review meeting, which Mr. Parker attended, the board raised the subject of the Deloitte review and why it had not been shared. The tone of the meeting was not one of anger, but definitely puzzlement. And said Mr. Parker's explanation was that he had been advised that the report was legally privileged and should not be shared with the board. So your evidence appears to be you were told of the Deloitte review, the report, and you attended a board meeting at which you asked Mr. Parker why he didn't provide that information earlier.
Yes, that's correct.
Please could we look at poll 406753. These are minutes of the group litigation subcommittee of Post Office on the 21st of February 2019. We see Tim Parker attends by phone, and then third down, you attend by phone as well. Yes?
Yes.
And we also see that Anthony Degar Robinson, QC, as he then was, gave, if we go down please, the upcoming Horizon trial, gave a briefing or an advice in conference on his views. If we turn the page, please. Number 4 says remote access risk. The claimants have posited the theory that Fujitsu had interfered with branch data in secret. Post Office Limited and Fujitsu's case on remote access had changed over time. Initially, Fujitsu had said that remote access was not possible. The Deloitte audit had found that it was. The claimant's expert was arguing that the scope for remote access was even greater than now stated, and it goes on to say what the court would do. So let's take it in stages. Firstly, you were aware at this stage, weren't you, that remote access by Fujitsu was possible?
My recollection was sometime between November and December 2019.
That's your recollection, but this is a minute from February 2019 at which remote access is discussed. So do you accept that you were aware of remote access by at least this date in February 2019?
From the minute that's in here, I have to accept that that's the case and my recollection's wrong.
And secondly, it refers to the Deloitte audit. So you were aware of Deloitte's involvement in an issue relating to remote access. Would you accept that?
Yes, I do.
If we look further down, please, we see questions. And the first one is about optimism on the claim. There's a note, the second, a note about a limit to planning that we could do before we had the judgment in the common issues trial. And a discussion there about risk mitigation. If we turn the page, please. It says there in this paragraph, whether an accusation was being made that Post Office Limited had been involved in instructing Fujitsu to change transactions. It was noted that only Fujitsu could change data, and there was no suggestion that Post Office had operated a policy to get Fujitsu to manipulate the branch data. The claim was that we had lied about Fujitsu's ability to change branch data. It was noted that it was hard to capture the number of instances in which data had been changed, especially in the legacy Horizon system, because of the way that data was captured. We could not distinguish easily between maintenance access and making changes to branch data. However, Fujitsu had been clear that branch data had only been changed on very rare occasions. And then we see it goes on to say about a line between bugs and systemic system errors and appeals. So from these minutes, it firstly doesn't appear that any surprise was raised at this information that Fujitsu could remotely access data. Do you accept that?
I do.
And secondly, there's no questioning raised such as, what is the Deloitte audit? Would you agree with that?
I don't see anything of that in the minutes.
From that, can we infer that members of this committee were aware of the Deloitte audit before this meeting?
According to the minutes, I would have to agree with you, but as I say, the dates were not my recollection, but I'm obviously incorrect.
So you can't assist us then. You've said in your evidence it's November 2019 or maybe December 2019. Looking at this document, you can't assist with when, before February 2019, you may have found out about this information.
It's in my witness statement, I've honestly, to the best of my recollection, said this is the date I believed I found out about remote access, and that's what's in my statement, that's what I believe. But you've obviously shown me something that where my recollection is incorrect.
Do you recall reading any of the reports into the Deloitte, the Bramble Deloitte report?
No.
Given what we said earlier about the significance of this, and you would have asked about the Deloitte reports, if you were aware of it, of the Deloitte reports at this time, would you have asked to read them?
Yes. I believe it was an error, certainly on my behalf.
Sorry, you say you believe it was an error. What are you referring to there?
I believe if I had been aware of the Deloitte reports, I should have asked to see them.
Can we look please, at a different topic. It's your approach to the litigation. Poll 406380, please. Now, this is a paper for the steering group on the 11th of September 2017, the group litigation steering group. You weren't a member of that steering group, were you?
I was not.
You only became involved when it was the subcommittee, the board subcommittee.
That's correct.
We see it says the title is Does Post Office Support the General Strategy Set Out Below? Do you recall whether you saw this document as part of your role as a senior independent director at the time?
No, I have not seen the document.
If you turn please to page 2, paragraph 4.3. We see the heading is overall post office strategy, and there's some discussion on that, and then we get to 4.3, which says we believe the better solution is to try to force the claimants into a collective position where they will either abandon the claims or seek a reasonable settlement. So I'm to refer to the litigation funder, and at the end says our target audience is therefore frees the funder and the insurers who will adopt a cold, logical assessment of whether they will get a payout, rather than the claimants who may wish to fight on principle regardless of merits. So to try to force the claimants into a position where they give up or settle, we recommend a three-pronged approach, which we don't need to turn to. Were you aware of that broad strategy of to trying to force the claimants into a position where they give up or settle, and focusing on the solicitors, funders and insurers?
No, I was not.
In your witness statement at paragraph 36, we don't need to bring it up, you say that you recall the board being advised that the claim was funded by a litigation funder and that their model would be to move quickly to get other claimants involved.
Yes, that's correct.
Can you recall the context in which you were told that there was a litigation funder involved and the purpose for why you were told that?
It was just a matter of fact. When the discussion came forward about who was representing the claimants. So it was only used as a matter of fact, a matter of information.
Could we look please at poll 20258 Sorry, bear with me. Please, could we go to page 2? And further down, please, to Jane McCall's email. Thank you. Refers to the case management conference last week and the decision of then Mr Justice Fraser on the strikeout application on striking out parts of the witness evidence that the claimants had filed. At the bottom we see it says, however, in deciding the application, the managing judge was very critical of our conduct of the case, intimating that we were not acting cooperatively and constructively in trying to resolve this litigation, which criticism was levelled equally between the parties, and that we had impugned the court and its processes by making the application for improper purposes. The response is extremely disappointing, as this has not been our intention, and his challenges to the purpose for which we had applied for strikeout is at odds with comments he had made during various procedural hearings over the past year. If we go up, please, to page 2 to see Mr McCall's response. See, Jane, many thanks for your note. Disappointing indeed. I would like to suggest we have a full update the next time we're all together, and say you leave it to Tim for thoughts on the discussion. What, if any, action did you take in response to learning about Mr. Justice Fraser's criticisms of the way the Post Office had handled the litigation?
I believe, if my recollection is correct, that's when we changed QC's, now KC.
No, this is before. So this is before the Common Issues trial.
Oh, I see. Then my view would be the tone and the approach that we took.
And what did you do to address the tone and the approach?
I personally don't recall, I don't recall specific conversations other than I've said, look, I think we need to discuss this, and I think we need the chairman to lead a discussion on what actions we should take. That was the purpose of my note.
That can come down, thank you. I want to go to a different topic, please, on contingency planning following in the run-up to the Common Issues trial. Please, can we bring up page 20 of your statement, paragraph 43? You say, I can recall being shocked at losing so badly when the advice from post officers' barristers had consistently been that we had the better of the arguments on most of the 23 separate issues under consideration. Against that very clear and confident advice, it was almost inconceivable that we had lost on all material points. I also did not appreciate, and I do not believe the board as a whole appreciated, how great an impact the Common Issues trial could have on Post Office Limited's day-to-day operations. The words you use there, better of the arguments, is taken from, or at least it's in minutes, recording legal advice was given. When you hear the words better of the arguments, how much confidence do you think the legal professionals had in the case when if using the term better of the arguments?
It's very difficult for me to comment on the legal professionals. My perception on the receiving end of those comments would be that we were in a strong position.
And when you say a strong position, if you were to put a percentage on it, what were you thinking of your chances of success?
Better than 50%.
As in anywhere from 51% upwards, or?
I think it's quite subjective to put a figure on it, but I would say consistently our legal advice had been that our arguments were strong, and that based on those arguments, my perception, and hence the use of my words, that I was shocked. I was shocked. I completely didn't expect what had happened. And so on that basis, I said, well, wow, how can we have got it so wrong? How can that be so wrong? How could this have happened based on our legal advice? And that's what I depended upon.
But from what you're saying, is it fair to say you hadn't considered this to be a certain victory, or had you considered it to be a certain victory?
No, I don't think you can ever say anything's a certain victory, but I certainly believed that there would be a better outcome than there ended up being.
Can we look, please, at poll 406754? So this is minutes of the meeting of the Sub-Postmaster Litigation Subcommittee. We see it's on the 15th of May 2018. At the bottom, we see that you've given your apologies. Would you have read the minutes of the meeting that were prepared when you were in readiness for the next meeting?
I think you would have to assume normally yes, but it's difficult to recall back in 2018.
We see Anthony Degar Robinson QC, and David Cavender QC are listed as in attendance. And page 1, if you go down, please. This gives an overview of the litigation. It says work out in common issues trial, should be trial, what the contract means. Phase 2, work out what the computer system worked. The next paragraph down, CI trial, common issues trial. What king of relationship those documents in the round constitute. We say business to business, but could be interpreted differently. Not straightforward because of the drafting, should be of the contracts, especially should be the older ones. I think actually when I say what king, that should be what kind, I think. Idea of good faith into contracts, especially relational contracts. We assume that's especially long-term arrangements. New law, unclear what a general duty of good faith would mean. And if we, it's there on screen, sorry. Overall view is that the Post Office has the better of the arguments in most 23 arguments. Don't think it likely that the good faith claim will be upheld, but it is material, there for him to do so, brackets, bit of a one-sided contract, etc. But in that case would advise Post Office to appeal. And then if we go to page 4, please. This is any view on how many of the 23 claims they're likely to win, 5 or 6 significant issues where it's not straightforward, brackets, go away and provide a summary, question mark, need to manage the comms angle and work out the implications, do a piece of work on impact of losing any of the 23 terms, aiming to bring this back in about July, looking at mitigations and what we could do now in addition to what I think we do if we did lose. Interesting to hear QC's view on most contention of the 23 issues. Do you recall discussing the advice with anyone who attended this meeting afterwards?
No, I do not.
Would you accept that it appears that the barristers that were advising that some of the issues were not straightforward?
When I read this document, even although the quality of the English is extremely poor, I'd have to say, yes, there are obviously issues that are not straightforward.
And that the Post Office may lose some of them?
Yes.
And it appears that the committee asked for more work to be done to analyse the impacts of a negative outcome?
Yes.
Can we look, please, at poll 406763? This is the meeting of the Litigation Subcommittee on the 10th of July 2018. We see that you're in attendance on the third line. If you go to page 2, please, towards the bottom, we've got contingency planning. It was noted that the QCs had presented their opinion on the merits of the case at the last meeting, and they concluded that, based on the information available to them at the time, on balance, Post Office had the better arguments. In order to understand the potential impact of an adverse outcome, the various terms sought by the claimants to be implied into the postmaster contract had been assessed from both a legal likelihood and an operational impact perspective, and had been prioritised using a simple RAG approach. These were discussed with the committee, and it was noted that, in general, those terms which had been assessed as the most likely, in fact, had a low operational impact, and conversely, those with the greatest potential impact were less likely to be successful. And it goes on to say over the page that the committee noted that the assessment was very helpful. if we look at that assessment now, it's POL 2025908, please. We can see it says draft contingency planning risk assessment table, and do you see the date is the 9th of July 2018 at the bottom left. Do you remember reviewing this document?
No, I don't recall seeing the document.
Do you accept this would likely have been the document that was before the committee?
It's very hard to say, and I don't recall seeing the document. And my solicitors actually asked from my feedback of reading the document, could we please have some more information on the document? Who sent it? What was it produced for? Who was it from? Who was it to? Who was it circulated to? And without that, it's very hard for me to understand. But reading it now, I don't recall seeing the document.
Well, I'm going to ask you some questions on it, and we'll just assist us as best you can. We see at the top, it says this document summarises in Council's opinion on the common issues. By its very nature, it is simplistic and should not be relied upon in lieu of a careful reading of Council's opinion. Where we have offered a view on the impact on Post Office, this is an initial view based on our current knowledge, and we have not sought to set out an exhaustive list of impacts. And then we see below that there's a RAG analysis or a grading table, and we see on the left its likelihood of red 5 being very likely to lose, right through to 1, Post Office is very likely to win the issue. And on impact, 5, a significant adverse impact on the business, right through to there will be negligible impact on the business. And if we just go through that, for example, page 3, if you go further down, please. Thank you. You see there implied term with a high likelihood 5 because it's been admitted, but low operational impact of 2 for cooperation. Over the page, please. Similar on exercise of powers. But if we go, please, to page 7. We see there at 11, there's an implied term about the relationship. And, for example, Post Office would not take steps which would undermine the relationship of trust and confidence between it and the sub-postmasters. And the operational impact has been listed as 4. Over the page, shortfalls. Implied term, Post Office would A, produce, keep and maintain accurate records of all transactions carried out using Horizon, B, be able to explain all relevant transactions, and C, use the records to explain any shortfalls. It's an example of 5 on the operational impact. So looking at that table again, do you agree that you were made aware, as a member of the Postmaster Litigation Board subcommittee, that there were a number of substantial adverse impacts on Post Office's day-to-day business operations in the event that the court disagreed with Post Office's interpretation of the contractual clauses?
In reading the document, yes, I understand it, but my response to you would be that I hadn't seen and I don't recall having seen the document, because I see no information that I've seen it or circulated to me, and I have no recollection of it.
I want to then move to your reaction to the judgment in common issues, please. It's POL 2039264. This is an email from you to Tim Parker on the 13th of March 2019, so shortly after the judgment in common issues. It says, Tim, apologies I was not able to stay on the call longer. Anyway, I understand we have a further call week of 18th to be scheduled. Outside of the call, I assume that's would appreciate a private conversation with you on this topic. I'm pausing there. We see the subject says GLO call. And it would be great if you could let me know what might suit. Can you recall what your private conversation with... Well, firstly, can you recall if you had a private conversation with Tim Parker following this email?
I don't recall specifically, no.
Well, do you recall what type of things you discussed with Tim Parker in private conversations following the GLO, judgment in common issues?
I have no recollection. I mean, we're talking March 19. I think to remember a conversation is extremely hard, so I don't have a recollection of it.
This was a pretty significant moment, wasn't it, for the Post Office?
Yes, indeed.
And is it fair to say you can remember your reaction to learning of the decision in common issues?
Yes.
So can you not remember, is your evidence you can't remember discussions you had in private with Tim Parker about that very issue?
I don't remember having a discussion in private with Tim Parker.
I want to briefly touch on the recusal application, please. Can we bring up your statement, page 24, paragraph 50? You refer to a debate and the board unanimously supported the recusal application, including Tim Franklin. You said no one on the board, to your knowledge, had been in that situation before. And the final sentence is, given the rock-solid advice from Lord Newberger and Lord Grabbanner that Post Office had no alternative other than applying to recuse Judge Fraser, recusal appeared to be the only logical way forward. Can you explain what you mean when you say no alternative? Why did you think there was no alternative?
Those were, because this was such a dramatic situation, I personally, and I believe my colleagues, had never been in a situation like this before. And the reason I remember those words is because those were the specific words that Lord Grabbanner used. And that's why I remember it. I remember those words specifically. If there's anything I remember, it's those words. We had no alternative but to ask to recuse Justice Fraser.
And when saying there was no alternative, can you recall what Lord Grabbanner said as to the reasons why there was no alternative?
There was a number of reasons in the discussion. There wasn't any alternative put forward, but there were a number of reasons. Reliability, credibility of Post Office witnesses, the accusation of inadmissible evidence, small issues being spread across the whole of Post Office, etc. There was a number of reasons and rationale why that apparently, according to our legal advice, amounted to apparent bias. And on that basis, that was the legal advice we were given.
So those are reasons why the application may or may not be strong or may not have merit. Slightly different question is the reasons given for why there was no alternative to make the application.
I don't specifically remember a discussion taking place that pointed out, here are three alternatives, or here is an approach. I don't believe there was that discussion. I believe there was a discussion about the rationale, as I've just explained. But other than that, there wasn't presented a case that said there's option A, option B, option C. We weren't given that.
Well, presumably you knew there was option A, make the application, option B, don't make the application.
That's correct.
So, in those circumstances, can you recall what was said for the reasons what Lord Grabiner gave for saying there was no alternative but to go for option A to make the application?
I can't remember his specific words, but as a layman, it's very difficult when we've got some of the strongest possible legal advice, when we have some of the most senior people in the legal profession giving us that advice, and none of the board had the experience of having been through this before, then it was our opinion that we had to follow our legal advice. In hindsight, maybe we should have been far more questioning and said, what are our alternatives? But I don't remember being presented with any at the time.
In your statement, you refer to Tom Cooper recusing himself from the vote on the recusal application. Now, in the board meetings, can you remember Tom Cooper expressing a view on the application?
I remember that in speaking, I remember, first of all, the chairman recused himself because of an existing accountability. And then, I don't remember the exact time, either just before or the day before, Tom Cooper recused himself. But it was my clear understanding that there was a unanimous opinion that we should proceed with recusal. I don't recall in any way, I have no recollection of any dissenting word that said no.
Did you have a view on Mr. Cooper's decision not to participate in the vote?
I had to respect his opinion.
You can respect someone's opinion and agree or disagree with it. Did you have a view on whether you agreed or disagreed with his decision to recuse himself?
I understood his position, but I was a little bit surprised.
Why?
I understood our chairman had a conflict which was very evident, but I wasn't sure what the conflict was in the case of Mr. Cooper.
Can we look at your statement, please? Page 25, paragraph 52. Turning down to the preparation for the Horizon Issues trial. Sorry, it's actually page, I'm not sure what I said, but it's page 25, please. You're speaking actually post-Horizon Issues trial. You say, I do not recall that losing the Horizon Issues trial came as a surprise to myself or the board. In contrast to the Common Issues trial judgment, the legal advice we received before the Horizon Issues trial judgment was much more pessimistic, given that we had lost the recusal application. It was clear Judge Fraser had a strong view, and for the reasons we applied to recuse him, and for the same reasons we applied to recuse him, such as his criticism of Paul's witnesses, we did not expect his findings in the Horizon Issue trial to be favourable to us. So I think what you're saying is the legal advice changed after the recusal application failed on Horizon Issues. Is that right?
I would say the legal advice we were given became far more balanced as opposed to convincing that Post Office had a strong case.
So you referred to losing the recusal application and you say about Judge Fraser's strong view. Are you saying that before Horizon Issues, but after the recusal judgment, you thought that Mr. Justice Fraser would find against Post Office because you believed he developed strongly critical views of the Post Office?
One of the key points put forward in our advice on recusal was his strong criticism of Post Office's witnesses. And on that basis, if those same witnesses were the witnesses in the Horizon trial, there was a strong belief that the arguments of Post Office would not be favourable to securing a judgment.
So at this point, did you think that you were predicting losing the Horizon Issues trial because of the judge's approach to the Post Office witnesses rather than the substance of the matters themselves?
I think it's very difficult to talk about the substance of the matters itself, because obviously myself and none of my non-executive colleagues were employed by Post Office at the time the historical or the legacy Horizon systems were in place. So my knowledge of those legacy systems is very limited indeed. My position here is that I said our inability to have Judge Fraser recuse himself was, in simple terms, due to 3 or 4 factors which would not stand us in good stead in the Horizon judgment.
Well, let's take one of those factors. You said the views you took of the Post Office witnesses. That was one of the grounds, I understand, you took into account when deciding to issue an application to recuse Mr. Justice Fraser, yes?
Yes.
And so you presumably believed that the strong view Mr. Justice Fraser had taken on some of the witness was a ground for arguing that he was apparently biased against the Post Office.
That was our legal advice.
Well, did you believe it?
I believed the legal advice.
But did you believe or did you agree with the underlying proposition?
I believed that that was a factor, but it was based on the legal advice that we had been given.
So when you're now thinking about the Horizon Issues trial and saying, well, we think our prospects of success are low because of the strong views Mr. Justice Fraser had taken, what did you think of the fairness of that?
I find it very hard to comment on the fairness. What I feel more comfortable commenting on was our legal advice gave a number of reasons which amounted to, according to our barristers, was apparent bias.
Ms. McCall, sorry, I interrupted you.
Sorry. And on that basis, given a collection of issues as opposed to just one issue on its own, we voted unanimously to proceed with the recusal application.
Mr. McCall, the point I'm trying to get at is whether you, as the senior independent director, and your view of the outcome of the Horizon Issues trial, whether you thought or believed that it was because there was a lack of robustness with Legacy Horizon as a matter of fact, or whether it was because you thought that the judge had taken strongly against your witnesses and it was just the outcome of a trial.
I think my knowledge, as I said earlier, my knowledge of the robustness of a Legacy Horizon system was very limited. I wasn't at Post Office. I had no knowledge of that system whatsoever. But the judgment that you're asking me on, I believe that the judgment was given on the basis of the Legacy Horizon system was not robust.
I want to look at now some of the issues after the judgment and the steps that Post Office took in response. Could we look at, please, Poll 30-21586? It's a Post Office board meeting on the 30th of June 2020. And we see you're there on the third line down. Could we please turn to page 5? We have postmaster engagement / representation. It says, Nick Reed explained that we were trying to rebalance the relationship between Post Office and postmasters, recognising the historical position in the GLO. The partnership during COVID-19 situation had been very positive and built up trust. We wanted to forge a proper partnership and make running a post office as an attractive proposition. It goes on to describe some road shows. The second paragraph says, Amanda Jones noted that the position had been moving quickly and the conversation with the non-executive directors and UKGI had been very helpful. We had taken on the suggestion to extend the consultation period, etc. Do you remember the conversations you had with Amanda Jones at this stage regarding postmaster engagement?
Not the specific conversations. I remember that Nick Reed carrying out roadshows to try and rebuild trust, to listen to sub-postmasters, to try and connect exactly with those people that were part of our network and that were running the most important part of our network. And so I remember the roadshows. I remember that the attendance was very good. I don't remember specific details. I think there was 4 or 5 or maybe half a dozen roadshows, and the information that came back was that they were welcomed, they were very positive, and they provided good feedback.
If we look at the bottom of the page, please. There's a bullet point that says, Tom Cooper noted that it was important to establish the board was comfortable with the proposals to include 1 or more postmasters on the board. All of the directors confirmed that they were comfortable with the proposal and would prefer that 2 postmasters were appointed to the board. It goes on to say they should be non-executive directors and remunerated as such. And then at the bottom, it says, as noted, we would need to think carefully about the selection process and also the credibility of the appointees with their constituency. Can you recall the discussion on the selection process and credibility of appointees at this board meeting?
I can't recall the specific discussion. What I do recall is that we were very keen to ensure that the sub-postmasters joining the board were recruited and independent. So therefore, it wasn't the post office choosing 2 people. It was actually the postmasters themselves choosing who the representatives would be. I remember that was the principle of independence, and the sub-postmaster should have the ability to do that. That's my recollection.
Were you involved in establishing or advising on establishing how the appointees would be selected?
I don't recall that I was.
That can come down, thank you. I want to ask you some broader questions which touch on the next phase that the inquiry is going into, phase 7. Aside from the what we've just referred to there, the sub-postmasters on the board, what are the steps had the Post Office Board taken following Horizon issues to to try to address the culture of the organisation and the criticisms made by Mr Justice Fraser?
There were a number of work streams instituted to try and improve the relationship. There was technology such as the branch hub system, which was to try and address the speed, the feedback, the ability of sub-postmasters to go online and address any challenges or queries they had themselves. The ability of Post Office through that branch hub network to be able to communicate far faster and far more quickly to sub-postmasters. There was a strong push to try and improve the communication, in addition to having 2 sub-postmasters on the board to help advise, guide and give the board confidence that the sub-postmasters were being represented in terms of strategy, communication and support. So there was a much stronger push to get a lot closer to the network and the people through some of these initiatives.
And as at the time you left, which was January 2022, what did you think of the adequacy of those measures in practice?
My recollection is that we had high 80s, maybe 90% of the branch network connected and working with Branch Hub. The 2 sub-postmasters were an excellent addition to the board and gave really good, strong, at times, and honest communication and feedback. And I thought they were doing an exceptionally good job in representing the sub-postmasters. And I felt Nick Reid was really strongly trying to get as close as possible to the sub-postmasters and improve the relationship between Post Office executive and the network. So I felt that the moves that were made were very positive.
What was the culture of the board like at the time you left?
I left in January 22. Myself and my colleagues who were there tried our hardest to address the historical issues and to, in some small ways, try to put right what had gone wrong, as none of us had been in position at the time. And so the culture was one of trying to help, trying to assist, trying to address the historical issues, and trying to work hard to build the credibility. And there were some very talented non-executives that were still on the board of the Post Office. And so I would say the board culture was very positive indeed. And Mr. Parker was a good chairman that was very inclusive in trying to make sure the board was very focused indeed.
You mentioned already Nick Reid. What was your view of him as chief executive in dealing with the issues that arose from the GLO judgments?
He was a strong communicator. He tried to get round the network as much as possible. He would welcome feedback. His style was open and engaging, and he was also detailed. And so therefore, I was very positive about his approach to rebuilding trust between the Post Office and the sub-postmasters.
And what about the relationship between Nick Reid and Alistair Cameron? Do you have any views on that?
In what terms?
Well, I'm just asking if you had any comments to make on if it was an effective working relationship.
I never saw that it wasn't an effective working relationship.
Do you have any other views on that matter?
No, sir.
What are your views on the composition of the board when it left, in terms of did it have sufficient expertise to deal with the matters before it?
As I said earlier, I believe it was the year before I finished my second term and stepped down. And Ben Tidswell, who joined the board from a legal professional background, was a great addition to the board. And I felt that was very positive indeed. The chair of the audit committee was extremely competent and an experienced executive, and as was one or two of the others. A replacement had started for me, but that was his first board meeting, so it's impossible for me to comment. But I was certainly very positive, although it was going through a period of change with me leaving and with the chairman going to leave later in 22.
The inquiry will be considering issues of corporate governance and the role of non-executive directors in when it considers matters. Do you have any thoughts or recommendations, having reflected on matters, for any changes or proposals you would make that to corporate governance or the role of the non-execs to avoid something like this happening again?
I think I'd have to reflect on that and take a bit more time to answer the question in any sort of level of detail. It's very hard when you are attending as a non-executive 1 or 2 days per month to get, other than the agenda and what is on a board or a subcommittee agenda, is very hard to get a much stronger feeling throughout the organisation on the culture or the effectiveness. I certainly feel that the induction could be strengthened, both in Post Office and on the government's expectation of a non-executive in that company. But I viewed Post Office as a trusted institution that had been around for hundreds of years, and I felt no requirement to do strong investigations or due diligence before joining. It's something I regret now, and I should have paid more attention to. But I think the training and induction and the expectation of the major shareholder, and I think also the complication of the business, because at the time, you know, this was a financial services banking joint venture. It was a broking business. It was a payments business. It was a mails business. It's a parcels business. It was a complex business. And I think making sure that any induction and process takes account of all those businesses would be more preferential.
Just picking up on one thing you said there. Do you think that 2 days per month for a non-executive at Post Office is insufficient time to carry out the role effectively?
I think 2 days per month under normal circumstances, and I caveat that because most of the non-executive appointments, leaving aside Post Office itself, most of non-executive appointments are 2 to 3 days per month. That's a common figure and should be sufficient. In the case of what has happened here, patently it would have been, and we ended up spending a lot more and allocating a lot more time to Post Office, but normally it should be sufficient.
Thank you. Those are the questions I asked. Sir, I'm just going to check if there are any co-participant questions, and then if there are, we can, or if there aren't, we can take a view on whether it's an early lunch or a break, I think. It's just Ms Patrick who would seek 5 or 10 minutes. I'll just look at the transcribe. The transcribe is happy to continue, and we could then take an early lunch. So
yes, by all means. Over to you, Ms Patrick.
Thank you, sir. Mr McCall, my name's Angela Patrick, and I asked questions on behalf of a number of sub-postmasters who were prosecuted and convicted and have since had their convictions overturned. And you can see two of my clients are sitting next to me, Mrs Hamilton on the left and Miss Hall on my right. And you'll be glad to hear I've got one issue and one document I want to go to and ask you about. But before we go back to that, I just want to set the scene. You can recall, I think, Mr Stevens took you this morning to a minute from February 2019, where the issue of the Deloitte reports were discussed. And he asked you, so your evidence appears to be that you were told of the Deloitte review, the report, you attended a board meeting at which you asked Mr Parker why he didn't provide the information earlier, and then you replied, yes, that's correct, having seen the minute. He also took you to a minute of 21st of February, and I think, if you can recall, that's the one where you and Mr Parker attended by phone. And again, Deloitte and remote access were discussed. And can you recall that exchange with Mr Stevens this morning?
Yes, I do.
Of course. And that'll just set the scene for the document. Can we look at Paul 2011699, please? I'm sorry, we'll just wait for it to come up. And if we can scroll to the last page, which is page 3, I'd be very grateful. And if we can scroll a little bit further down, please. You see there at the bottom, you can see there's a dial-in detail for that minute, that meeting, GLO subcommittee, 21st of February 2019. You see the meeting was to be 11 to 12, and the various dial-in details, including your name there. Can you see that, Mr McCall?
Yes, I do, thank you.
Can we scroll up a little, and we can see where this email goes. If we scroll a bit further, I can see that first message. You see there's a message there from Tom Cooper, and it isn't copied to you, but just to set the scene, he says, Jane, one follow-up from the call. Presumably that was the meeting earlier that morning, so the timing on this is 12:47. If we read it together, he's asking, to what extent can the court protect Paul against journalists overstating the evidence re-Horizon? If a journalist writes that there's evidence of systematic problems with Horizon, when in fact no evidence exists, will the court help us at all? It seems to me it's incredibly important to have a press strategy which seeks to stop misrepresentation by journalists and seeks to protect Paul's business today against the implication that the current system doesn't work properly. And that's to Jane McLeod, I think. There's no other Jane on the message. Now, this is after the meeting, where there's a discussion with Mr Degar Robinson, and there's a conversation about the Deloitte report and remote access. Now, here Mr Cooper's asking about how to protect the position of the Post Office in press reporting during the GLO, isn't he?
Yes, that's what's written there.
Was that a concern that was shared more widely on the board or on the subcommittee?
Not particularly.
But the subcommittee we see here could be involved in strategy for the Post Office during the GLO, including on communications and interaction with the press. Is that right?
No, I think the subcommittee was involved in items that were escalated by the day-to-day executive who was managing the litigation.
It would be open to you as a member of the subcommittee in the way that Mr Cooper is here to ask questions about anything around the strategy on the litigation. Is that fair?
That's fair, but as you can see from this email, I'm not copied on the email, so...
I'll stop you there, Mr McCall. If we can scroll up so we can see the next message in the thread. Stop there. We see Miss Venel's replies very shortly thereafter at 1:21, and she does copy you in. Can you see that there, Mr McCall?
Yes, I can.
Yeah. So you are copied in, and you see Mr Cooper's question to the other members, to the members of staff, but also copied to his fellow subcommittee members. So you did receive that message, didn't you?
It says there's an email, and I'm sure I then received it.
Okay. And I just want to have a quick look at what Ms Reynolds is telling you about the strategy in response to Mr Cooper's inquiry. She says, yes, we defend robustly, but we avoid adding extra coverage. And if you recall, this is after the meeting where we know that you've had a conversation about remote access and Deloitte. As before, we hold the ground. The system is robust, and not comment any further during the trial. So aggressive, no. Robust, absolutely no question. And if we scroll down a little bit further, we see she's talking a little bit about the strategy and how it has gone so far. The strategy has worked well so far, which is to minimise coverage in mainstream media. Therefore, we don't engage in any public debates. We have strong lines, but we add no oxygen by commenting or engaging. This is not new news, despite how the claimants will present it as that. Our approach is to curtail interest as much as possible. And then she goes down to sort of talk about the question about legal options that Mr Cooper has raised. Your questions re how far we can go legally are important. We have used injunctions and demanded apologies in the past. They're both to be used, but with caution. They gain more coverage, which is not always balanced, but there are tools in the box. Portland are very experienced about this too. Portland, was that an external PR agency that the board was consulting?
That would be the responsibility of the executive. I don't know the name Portland specifically, and I never met anyone from Portland, so I'm presuming in the circumstances of what I see written, it would be managed by the executive, and that's who they are.
So here, Ms Reynolds is writing to the whole subcommittee, updating you on the approach they're planning to take to the strategy around the GLO. She's saying, maintain the position that the system's robust, strategies to be aggressive, no. Robust, absolutely no question. Was this the strategy towards press engagement on which the subcommittee was essentially agreed?
Well, the subcommittee weren't responsible for the press engagement. There was a communications director working with the CEO and the General Counsel, and they were responsible for all the day-to-day strategy around communication and what was said by the company, in addition to shareholder input. So the subcommittee wasn't on a day-to-day basis involved in this.
Okay. Can we just scroll up a little to see the last in the line of questions, last in line of communications? On the first page, I think we should see. Stop there. We see Mr Davies responds to Miss Reynolds' outlining of the strategy, and again copies you in. And we'll take this very briefly because it's essentially repeating the message but with some greater detail. External communication strategies to minimise negative coverage by holding the robust line we have deployed throughout. In so doing, we've succeeded in minimising coverage in the mainstream media. I don't want to cover this in great detail because he goes over how different approaches have been taken in the press. But he says, there is a group of journalists who have staked their professional reputations on campaigning on behalf of those who have now taken us to court. They, and one in particular, drive most of the periodic increases in external coverage. We sought to engage with this group, but there's an unwillingness to engage with our side of the story. And if we skip down a little further, Private Eye has also featured the issue regularly, claiming Post Office has knowingly covered up evidence of what it calls the deeply dodgy Horizon system. We believe the content in Private Eye is almost certainly provided to it by one of the campaigning journalists who have staked their reputation on proving that the Post Office has conspired to see otherwise innocent people jailed or penalised. Now, first, Mr McCall, can I ask you, how closely did Mr Davies work with the subcommittee at this time during the development of strategy on the GLO?
as I said, let me repeat again, Mr Davis, the General Counsel and the Chief Executive were responsible for the communication strategy and anything that was responded to by Post Office. The subcommittee wasn't day-to-day responsible at all.
Just stop you there. I've got one last question for you, Mr McCall. This is February 2019. You're talking, this message, which goes to the whole subcommittee, talks about the campaign. There's been a campaign by this stage for a very long time in which my clients, including Mrs Hamilton and others, were deeply engaged. They'd managed to get their case into court. There was a subcommittee of the board set up to lead the strategy on that litigation. You are the senior, independent, non-executive director. You've agreed today that part of your role was to represent the interests of the shareholder, who is the taxpayer, the government. Are you really suggesting, at this point, and if I can remind you, you've accepted, the board would have been aware that the picture on remote access was very different from that which may have been presented at an earlier stage? Are you really suggesting that if you thought that the strategy that was being presented by the executive team was out of step or might be causing some risk to the business, that you could not step in and say something?
I'm suggesting to you, and I'm answering to you quite firmly, the subcommittee is not responsible for the communication strategy. There was a document produced earlier today talking about the strategy of the litigation. I didn't sit on the subcommittee of that. I had never seen that document before. And I'm copied in here on an email, but I'm not responsible for the communication strategy. I was the senior independent director, and I accept that. And I received the email, I'm absolutely certain, but I wasn't responsible for the strategy.
Okay. Thank you very much, Mr McCall. I don't have any other questions for you.
Is that it, Mr Stevens?
That's it, yes, sir. So, yes,
Right.
That's all the questions.
Fine. Well, thank you, Mr McCall, for making a witness statement as the inquiry requested of you. And thank you, too, for giving evidence this morning before me. I'm very grateful to you.
Thank you, sir.
So what time should we resume, Mr Stevens?
So I wonder if we could resume at 25 to 2, and then, because it will be a longer session, take 2 breaks. But that should give us sufficient time, I think, to cover the evidence.
All right. 25 to 2.
Thank you, sir.